All right, good evening and good morning, everyone, our attendees, presenters, our moderator, and colleagues who are joining us today. Welcome to the third part of our webinar series, Natural Resource Policy, Culture, and Law. Because we are streaming this, well, I'm streaming this from Los Angeles, we're going to start with a land recognition. So before we start, we would like to recognize that as a land-grant institution, the Center for Southeast Asian Studies at UCLA acknowledges the Gabrielino Tongva peoples as their traditional caretakers of Tobangar, the Los Angeles Basin, and Southern Channel Islands. The topic of today's session is tenure and use rights across the traditional lands and waters. This session will consist of 4 presentations from our speakers, followed by a brief Q&A section. Our attendees, you are invited to use the Q&A feature on Zoom to ask your questions. And if you're on Facebook watching, you're welcome to leave your questions in the chat box and we'll check back there. I'd like to now briefly introduce our panelists and their topics. First up is Valmain Toki from the University of Waikato, Customary Tools to Achieve Sustainability, Rahui and Moana, a case study. Then we have Bruce McIvor from First Peoples Law, LLP, Aboriginal Title in Canada and the Foreshore. Third up, we have Frank Bibao from a tribal attorney for Honor the Earth and the White Earth Band of Ojibwe, the rights of nature and the protection of treaty rights. And lastly, we have Bradley Cardozo from UCLA, Climate Justice, Indigenous Politics, and Coaligarchy, the threat of coal power expansion into the ancestral domain of the Aita Magbukun people of Bataan Province, Philippines. And our moderator today is Professor Awi Bona from National Donghua University. And with that, I will turn the floor over to Professor Awi for the remainder of the session.
Good morning, everyone. This is Awi Mona, and thanks for Madmin's introduction. And it's my great honor to be part of this webinar series. And hello for my all panelists, Professor Vamin, and Bruce, Frank, and Bradley. So I think today's discussion is very important for the indigenous peoples across the globe. Especially for myself in Taiwan, I'm not sure whether all of you has aware that in Taiwan, since last May, the Constitutional Court in Taiwan has released its very important decision on indigenous hunting rights. And followed by that, we have a series. It's not really a series, but it's just case after a case. A number of different courts in Taiwan has made a court decision, especially on today's discussion, on today's topic. Like we have coal company expansion and continuation will be conducting their exploitation on indigenous traditional territories. And we have a lot of things going on right now in Taiwan. So I'm very excited to hear and to learn a lot from all our presenters today. So to set the time for our panelists, I think the Valmin has already introduced what each one of the panelists' topic. So I'll first turn the floor to the Professor Toki for her presentation first, and we will follow by our agenda. So you have the floor, the Professor Toki. Thank you.
Kia ora. Tēnā koutou katoa, tēnei te mihi ki ngā tangata whenua. Ko Valmin tuku hau ngō ngā pui me Ngāti Wai. Good afternoon, good morning, good evening, everyone. It's a privilege to be part of this webinar series. I'd like to thank the organisers and also acknowledge the expertise of my fellow panelists. I understand this session is to focus on tenure and use rights across traditional lands and waters. And with this in mind, I'll just share my PowerPoint. With this in mind, my presentation speaks to using customary tools such as Rahui and Moana to achieve sustainability. My presentation is really in 3 parts. So firstly, what is a problem? Secondly, after identifying the problem, providing an Indigenous solution, and thirdly, look at the current adoption of these Indigenous solutions through discussing a couple of case studies. So Arahui first, and intrinsic within Arahui and Ahu Moana approach. So firstly, the problem. Considering the issue of achieving and maintaining sustainability, this presentation focuses on how to achieve and maintain sustainability for our kaimoana or seafood, our fishery and our moana. The problem here in Aotearoa, New Zealand is the loss of our fishery, and with that, the associated flow-on or knock-on effect of the loss of our ecosystems. In Aotearoa, New Zealand, we have the legislative quota management system to guide the sustainable use of New Zealand fisheries. The quota management system is in the Fisheries Act, and what this does is it creates a private property right with catch limits. However, we're taking more fish commercially, and in some instances, the rate is 30% more across, I think, the recent 3-year period. Subsequently, the numbers of species such as coda or crayfish has been substantially reduced, and crayfish, or what we call coda, are now regarded as functionally extinct in heavily fished areas. Some commercial crayfish fishers have actually struggled to catch their quota, so they have decided to voluntarily shelve their catch. And research within this area suggests that these reductions in populations of coda or crayfish have allowed kinnibarrens to flourish. And what this does is it causes the loss of our kelp forests and expansion of kinnibarrens within those subtidal reefs. So this really indicates two issues. First, a changing environment for our fishery, and secondly, that the current methods are not working and not providing for a sustainable fishery. So looking at an Indigenous right or an Indigenous approach to our fishery, to our moana, in contrast to the Western legislative approach that creates a private property right to fisheries, Maori take a te ao Maori approach or a tikanga Maori approach. The Maori, like all my Indigenous brothers and sisters, have a spiritual connection to the environment. Maori conceptions of the environment and natural resources, such as fisheries and the climate, are sourced in our cosmology. This cosmology assists to govern and understand that relationship. So if we think about the separation of Ranginui or Sky Father and Papatūānuku, Earth Mother, in our creation stories, this resulted in the birthing and developing of different ecosystems such as rains, mists, dews, and they symbolized the tears of separation, and the blood from the tearing of the sinews joining them became our sunrises and our sunsets. So this separation and ongoing conflict between the children of Rangi and Papa symbolizes that ongoing struggle between different aspects of the environment. And this is all part of a whakapapa relating to the gods, the natural world, and humans. So as whakapapa relates us as Māori to the environment and that these elements are our relations, the concept of whanaungatanga extends that obligation to non-human relations also. So basically we are all related and we should treat each other with respect. In Māori, we develop customs to look after the life force or the mauri of all these natural resources. And why? Of course, to ensure that sustainable management can occur. We don't have any concept of ownership of resources such as a fishery, rather it's mana or authority and control over access and use. The resource, like fisheries, is recognised as a tonga or a treasure protected by kaitiaki or guardians, and what they do is they mediate the relationships between the resource and the people to maintain the mauri or the life force of that resource, and in this case, the fishery. So the philosophy that underpins tikanga Māori includes concepts such as guardianship or kaitiakitanga, manaakitanga, a duty to look after, tonga tuku iho, so for future generations, and kotahitanga, so coming together as one. And when we think about tikanga Māori, the aim is to achieve balance, and the interaction of those concepts are to preserve intergenerational and intra-generational equity. And that's consistent or analogous with the whole concept of sustainable management that we all understand and know. So in a nutshell, Māori have a right or a raft of rights to their fisheries. So the cultural right, which I've tried to very quickly capture, and also that tikanga Māori right, but more implicitly, we have a treaty right through the Treaty of Waitangi. And we look at Article 2 of the Treaty of Waitangi, and in that article included a right to a fishery. And this right was provided for in a treaty settlement with the Crown. And part of this recognition is the inclusion of customary tools, and that's reflected in Part 9 of the Fisheries Act. So the Indigenous tools include a mahinga mataitai, a taipuri, and a rahui. And a rahui is what I'll be speaking to today. And these inclusion of these concepts, as I mentioned, are in our customary fishing regulations. So it's all about Maori exercising their obligation as kaitiakitanga or as kaitiaki or caretaker, in this instance to lay a rahui or to lay a ban, and this is all to protect and maintain their moana, maintain and protect the resources, and to eventually achieve a sustainability within that concept. So turning to the case study to, I suppose, highlight or crystallise our understanding on how it actually works. So I'm actually from a small island, which is 50 nautical miles east of Auckland in the North Island. We understood as a community, as a Māori papakainga, that our fishing resources and ecosystems are suffering. So what we did is we got together as a community in our marae and we decided to lay our rahui around home, around Aotea or Great Barrier Island. So what we did is we laid the rahui according to our tikanga. So what happened is it was undertaken in a dawn ceremony. There was a karanga or a traditional calling from the land. There was a karakia over or a blessing over the boats who went out to lay the rahui. And once we were out on the water, a rahui was cast over Aotea and specifically focused on 3 species that were showing signs of rapid decline. So the crayfish that I've sort of spoken to at the front end of my presentation, but equally we have decline in paua or abalone and scallop. So this rahui was laid traditionally to focus on those three species. In conjunction with this tikanga approach, a formal legislative avenue was also undertaken. So we made a formal application through Section 186 of our Fisheries Act to the Minister to ask him to close that area off with legislative force. So this rahui is an example of Māori understanding that their resource is suffering and deciding to turn to our own tikanga and be proactive in that space, exert our tino rangatiratanga over our area and say we're going to lay a rahui, and we know that there's legislative support to do that. And so there were like two avenues to ensure that we're doing everything to ensure that we have a fisheries resource for future generations. This is just another picture of someone laying, actually he was in the middle of a karakia at the time to lay the rahui. So we laid the rahui on the water because we felt it was the most appropriate way to cast a karakia over our motu, over our island. So in addition to a rahui, and I'll just talk to this very briefly, is we've advocated for an ahu moana approach. So an ahu moana approach is relatively new, but in saying that our government understands, our current government anyway, understands that the current methods are not achieving sustainability. They have decided to support an ahu moana approach. So an ahu moana approach is the mana whenua or tangata whenua or Indigenous peoples working in together with the community to try and restore their fish stocks, if you like. So I think that the rahui was an intrinsic part of an ahu moana. So now that we've got a rahui laid over Aotea or Great Barrier Island, what's important for us now is to then support bespoke programs within each section of our island to support the restoration of that particular fishery, because we know who looks after the area most, the people that are living right next to it, right? So there's that lovely organic understanding of it's a community, or the flax roots that we like to call it, the flax roots approach to restoring our fish stocks. because we know that if we don't look after our kaimoana, we won't have any kaimoana the following day or the following month or the following year. So there's a vested interest, if you like, in the community, in mana whenua, in tangata whenua, to say, okay, we're going to be proactive, we're going to exert tino rangatiratanga in that space and implement programs that we know will restore our kaimoana. So on this next slide, it's just taken from the State of the Gulf report, and this is what they mentioned, what an ahu moana approach. So it's really mana whenua or Maori Indigenous peoples acting as a kaitiaki or a guardian, local communities as well, working together to really just restore our kaimoana. So this is all about tino rangatiratanga. This is all about and it's all about asserting that within our own rohe. It's all about being proactive. It's all about saying, okay, we know our fish stocks are declining. We need to take action in this space. We have arahui recognised legislatively, but irrespective of that, arahui has that moral effect, right? So between now having the rahui being laid and it being recognised under legislation, it has that wonderful soft moral effect, if you like, or soft law approach. So when we're out on the water, we can say, well, actually, there's a rahui here, and over certain species, and people hopefully will respect that. But more so, the word will go out that there's a rahui around that, and that's like one way of enforcing how to restore our fisheries, and we have the legislative approach as well. But if I have time, I just wanted to mention very quickly. Do I have time, Mr. Moderator? Do I have 5
Yes,
minutes?
you still have time.
Oh,
Yep.
great. So what I did want to mention is, so rahui under legislation is an area that's basically closed off, and you can't, there's like a no take from the area. What we want to implement is a tikanga approach, right, to that. So we want to ensure that our old people, or in times of a tangi or a funeral, can apply to our marae, or our elders or our kaumata, and say, actually, we need to access those resources for our tangi. And we want to ensure that we can still facilitate that tikanga approach, because it still supports our community. And if we are kaitiaki, if we do take seriously restoring our kaimoana, then that will be taken in the correct manner. So that's all kind of happening at the moment here. But are we turning to traditional tools, because the quota management system clearly is not working, and it's in the Hauraki Gulf where we live, it's in dire straits basically, primarily because there hasn't been that mindful eye over those resources. And what's really promising is that iwi, our neighbouring iwi, and the Coromandel and also on the mainland, have also laid down a rahui. So it's kind of this lovely turning around of iwi Māori and saying, okay, we need to front foot this. The government isn't, the quota management system, all the systems in place aren't working for us. Let's front foot this, be proactive, assert tino rangatiratanga over that space and lay a rahui. And that's kind of really, I think it's kind of cool really. And I firmly believe that our fisher stocks will recover with that collective approach. And that's really all I wanted to speak to, but I'm happy to answer questions afterwards. Kia ora koutou.
Okay, thank you very much for Professor Tokes, this insightful presentation, because I think for myself, I learned a lot, especially on the idea of the tikanga approach. And another thing is when you mentioned about when you explain the community with the Mana Whenua, I think that's a great experience for, we have a small island on the southeastern part of Taiwan. We call the Oki Island. They are also have a long history of legal conflicts on the fishery rights, on the management of the fisheries. I think maybe we can have more discussion on that, and we can follow to discuss on how can we include the indigenous legal traditions to interact with the state law, even the management systems. So followed by Professor Toki's talk, and the next speaker we have is from First Peoples Law Center, Professor Bruce McHaver, and he will be talking about Aboriginal title in Canada and the foreshore. And please.
Great. Well, thank you very much. Thanks for the invitation to be part of this great event. And thanks very much for the rest of my panelists for making space for me and sharing your knowledge. I'm talking to you today from Vancouver. So that's the unceded lands here of the Squamish, the Musqueam, and the Tsleil-Waututh. And what I do, just for a bit of background, I'm a lawyer and I represent Indigenous people all across Canada, coast to coast to coast, as we like to say, on their Aboriginal title and treaty rights. And I also teach the odd course on this at UBC, at the University of BC Law School. So what I thought I'd chat a little bit about here today was just what are we talking about when in the Canadian context, Aboriginal title, what is that? And what's it based on? How the laws developed a little bit, where we are currently on the specific issue of Aboriginal title to the foreshore. And I just end off on a bit of a comparison piece because I had the good fortune last year at this time to appear as an expert witness on behalf of Maori claimants at the Waitangi tribunal about the foreshore and Aboriginal title. So just a little bit for those not from Canada, what are we talking about when we're talking about Aboriginal title? In Canadian law, I think the first thing is it's not inherent Indigenous title to the land. And I think this point that Professor Taki was making really resonated with me. How do you translate these things? And in Canada, the approach has been from the courts, it all needs to be translated into concepts and a language recognizable by the common law. So that's one of the issues that Indigenous people have all the time, is that legal translation. And as we all know, what's lost in translation when you're doing that. So when I'm speaking about Aboriginal title, it's a concept created by the Canadian courts. It's not necessarily my client's idea of their own Indigenous inherent title to the land. So that's the first point. Second point, under Canadian law, what it is, when it boils right down to, it's two main things. One, it's the right to decide about how the lands are going to be used or how they're not going to be used. And the second is, it's the right to benefit from the lands. So in that sense, it's something similar to a fee simple interest in the land. It's not simply a right to use the land, a usufructuary right. It's an interest in the land itself, but it's not identical to common law property interest. So those are the main two things. It's the right to decide And then we, here in Canada now, we get into a conversation about consent and so forth. And then it's a right to benefit from the lands, and it's not restricted to what you might term as gathering rights or usufructuary rights over the land. It's not absolute. So it is constitutionally protected in Canada, and that's the difference. I know for a lot of jurisdictions in Canada, it's been constitutionally protected since 1982. So it can't be extinguished. And if something that government does is offside, that protection rules the day at the end of the day. But it can be infringed on. So it's not absolute. So in Canada, similarly, we have charter rights, freedom of speech, mobility, etc. Those aren't absolute. They can be limited in a similar way. Aboriginal title in Canada is not absolute. A couple more characteristics. It's a communal right. So it's not an individual right to the land. It's a right by a rights-bearing community. So it's a communal right to the land. And this gives rise to an ongoing tension in Canada, this discussion between individual rights, liberal democracy, ideas of rights, as compared to collective rights held by Indigenous people. So it's a collective right to the land. Lastly, there are a couple of limitations. One of it is, this dates back a long time, if it's going to be, quote, surrendered, it can only be done so to what we call in Canada the Crown. So the government, and Indigenous people that hold Aboriginal title, they can't do things to the land that would disentitle future generations. And this is because the purpose of rights protected under the Canadian Constitution, the fundamental purpose is to ensure the perpetuation of these distinctive Indigenous peoples into the future. So when Aboriginal title, if it's confirmed, declared, the Indigenous people that hold that land can't do something that would destroy their connection to the land and protecting it for the future. So that's just a bit of an outline of what we're talking about with Aboriginal title. How's it developed? Well, it's the main case in Canada began was back in 1973. So the Canadian courts have been developing it very slowly since then. The main point of it is that it's based on a fundamental principle. And that principle is that when the colonizers showed up, so for us here in BC, when Captain Cook, and those of you in Australia and New Zealand, when he came lost, kind of floating in to Vancouver Island here, Indigenous people were there on the land, practicing their own laws over the land. And Captain Cook showing up didn't suddenly make that disappear. So that's the basis of Aboriginal title in Canada, those pre-existing rights to the land. And now how do we deal with that in 2022? So the laws developed a bit. The main point on this, I think, is that in 2014 in Canada, we finally had our first court declaration of here lies Aboriginal title rights. This has been a frustrating thing for Indigenous people for a long time, is to go through the courts, and the Supreme Court of Canada has been heavily involved in developing the law. So in 2014, the Silcotin, who are in central northern British Columbia, were finally successful at the Supreme Court of Canada to get the court to say, here's a map, and on these lands, there is Aboriginal title. Now, for Canadian Indigenous people, that was quite the event, because we'd gone through complete denial, there's no such thing, to it's been extinguished, to maybe it exists, we don't know what it is, to this is what it is, and there it is. And you can go out there and stand on Aboriginal title in Canada. So that's what was a watershed moment. Where are we now? There are a lot of outstanding issues, though. One of them is, how does this interact with private rights for fee simple rights to the land? Court never addressed that. So what do you do when you had governments issue certificates of indefeasible title 100 years ago, 150 years ago? And now you get descendants of colonizers holding it up and say, I own the land. And you get Indigenous people say, well, where did you ever get the authority to issue that colonizer that certificate of indefeasible title? And the court scratches its head and says, yeah, that's a good point. You know, particularly in large parts of Canada, what the courts have said is governments have run around acting like they own the land de facto with no legal basis. But they've been acting like they own it long enough. And now the tension is, what do you do with that? So that's a main outstanding issue. Second one is this issue of title to the foreshore. So this is a really interesting one. The laws developed around dry land. So you would be able to prove Aboriginal title in Canada if you could show at this, what we call here in Canada, the date of the assertion of Crown sovereignty, which I like to say is a Canadian euphemism for the doctrine of discovery. In a very Canadian way, we don't like saying it, we use it, but instead of saying it, we call it the assertion of Crown sovereignty. And thanks to the Marshall Court in the United States in the early 19th century, that's been secreted into Canadian law. Here, another thing the courts don't like to acknowledge, but it's fundamental. Fundamental. The constitutionalization, the protection of Aboriginal rights in Canada is based on, and I've written about this a lot, this rotten foundation of the doctrine of discovery. The early Supreme Court of Canada cases beginning in the 70s would just cite and refer to the Marshall decisions. Yeah, that sounds right. The colonizers could show up, own the land and displace Indigenous sovereignty. No one really figured out how. And now since then, the courts in Canada have used the same principles, they just won't say it anymore. So they stop citing the Marshall decisions. But so that's what it's based on. Those use and occupation of those lands at the date of the assertion of Crown sovereignty. That'll change across the country, as probably some of you know, Canada, like our friends to the south in the US, colonized at very different periods. You know, this is a big country, and the colonization project on the Canadian East Coast, you know, began in the early 16th century. Here, where I am today, it was hundreds of years later. So you got to find a different date. Here in BC, the courts have said, well, it's 1846. So were you exclusively using and occupying the land in 1846? That's the basic question. And if you can show that you were, you have a chance of getting a declaration for Aboriginal title. So that's where we are. We don't know yet about the foreshore. There's been a few cases, not to the foreshore, but to lakes and rivers. And the indication here in Canada is that the courts will apply much the same test. So for the foreshore, and I testified at the Waitangi Tribunal about this, it would be a test, regular use and exclusive occupation of the foreshore. And that can be all kinds of uses, fishing, harvesting. Doesn't have to mean that you've set up some kind of settlement there. It's regular use and occupation at the time. So that's what it looks like it will eventually be. There are a couple of cases here, or more than two. I've got one on the East Coast where we've got a Aboriginal title claim. I think we filed it for a third of the province of New Brunswick. I don't know what that compares to, but it's definitely a big chunk of land. I know a lot of my American friends like to compare things to the size of Rhode Island. So that's probably 5 or 6 Rhode Islands anyways. So it's a big chunk of land. And our Mi'kmaq clients filed an Aboriginal title claim for everything. So-called crown land, private land, the foreshore, the airspace. My advice to them was go big or go home. So that's what they decided to do. So just one final point on this, because I think it's instructive and it fits a bit with the comments from Professor Taki, was, how does this work internationally? So what I was asked to do on behalf of Maori claimants at the Waitangi Tribunal last year was take a look at the legislated test for what we would call Aboriginal title in New Zealand and compare that to Canada. And I think the Maori that I was giving the report on had an idea that what they were hearing from the New Zealand government about this is all honky-dory, this fits with the way the laws developed in Canada was maybe a little bit questionable. And when I took a look at what was done there, that my conclusion were a few main points. One, that the test itself is laid down for customary marine title in New Zealand through legislation. One is much more restrictive than Aboriginal title in Canada. So how you could prove it, much more difficult. And secondly, if you were successful and if there was a declaration, it was more limited than what you would get if you had a declaration of Aboriginal title in Canada. So more restrictive, for more onerous for the test, more restrictive, and less of an interest in the land that you would get in Canada. And then fundamentally, I think just a misconception. And this goes to the differences in Canada. To a large extent, Aboriginal title is something when you don't have a treaty. So my comment was, what are you looking at the Canadian law on Aboriginal title for when you have the Treaty of Waitangi? The wrong place to start. And you have to keep in mind that the Canadian law on Aboriginal title is based on this fundamental lie. that colonizers can just show up and acquire a beneficial interest in the land and displace Indigenous sovereignty. Why would you ever base a test on that lie? So that was my fundamental criticism of where the New Zealand government has gone on this. Would make a lot more sense to start with the Treaty of Waitangi. And if you were going to look at Aboriginal title in the common law in Canada, keep in mind it's based on the doctrine of discovery. Is that really where you want to tie your pony? I don't know, right? And lastly, the way they had taken test was much more restrictive, onerous to prove it. And if you were successful in proving it, the end results were more limited than what you would find here in Canada. So those are my comments. And once again, I really appreciate the invitation and I'm looking forward to questions. Thank you very much.
Thank you very much, Bruce, for your talk and as a moderator. And I would like to say something before we go to the Frank. So because not unlike the common law country like Canada, New Zealand, Taiwan is more like civil law countries. Actually in Taiwan, we have already used the idea of the Aboriginal title into our written law. But unluckily in Taiwan, we kind of shrink this idea of Aboriginal title, just connect to the land claims, but not expansion to like water, sea, even the foreshores. So, and another thing is we haven't established some kind of standard, even a proving procedure yet. So we haven't, we have only have this idea in our law, but we are not into the point that even we can't claim original title onto the private land yet. So I think we can have more discussion on our following sessions. So this is just what my thought from your sharing, and thank you, Bruce. So the next speaker we have is the Frank sorry about that. I just call you Frank, okay? So we have Frank, we'll talk about the rights of nature and the protection of treaty rights. You have the floor, Frank. Thank you.
Okay, thank you. It's great to be here tonight. And it was interesting to listen to the other two speakers already because of the differences in our laws and the differences in our rights, but that our cultural perceptions and connections to the land and nature are very much the same. We just describe them in our languages a little bit different. And so I'm a tribal attorney for the reservations and things where I live. I'm a member of what we would call ourselves the Anishinaabe. In Canada, they would call it Ojibwe or Chippewa most frequently. Our treaties refer to us as the Chippewa, and we have 44 treaties with the United States, where most tribes have 1, 2, 3 treaties maybe with the United States. And so when you have 44 treaties, that's a lot of evolution. And it's almost like rolling contracts in a sense. And so the Chippewa, and I'll just use that term because of the treaties, and I use it a lot because of that. The Chippewa, their territory is mostly the Great Lakes. And it's approximately 800 miles across and about 1,000 miles north and south. And most of the Chippewa or Ojibwe live in Canada. The Canadian Ojibwe refer to us as the Southern Ojibwe here in the United States. And we think of ourselves as being up north just because of the way the boundary is between the United States and Canada. And so as I was listening to trying to figure out how the laws work, because our treaties, good or bad, the United States, with our treaties in 1825, they established a boundary between essentially the Sioux, which was another large tribe, and about another 10 tribes, and the Chippewa. And what they basically said was that Chippewa had a right to decide who hunted above, and that the Sioux primarily, but others in the other areas had a right to decide who hunted south. And so that's environmental regulation in a sense at the most basic level. You get to decide how the garden works, you get to decide what's going on with the food. And so there was a ratification treaty in 1826. And in fact, that treaty said that title to the land had not changed and that we still held jurisdiction. Now, jurisdiction isn't an old Indian word. That's a word that, colonial people use to tell other colonial people that they have the right to decide and we're working with them. And so the way treaties work in the United States, if they haven't been abrogated by Congress or haven't been modified by Congress, then they still exist kind of in their raw form, whether they've all been broken or not. Now, fast forwarding past Marshall and everything else that Bruce was talking about, in 1999, the Supreme Court, in the Mille Lacs decision, which has to do with the Chippewa here in Minnesota, in the Mille Lacs decision, they decided and determined that not only did we have all the rights that Bruce is talking about before the Crown came along, and we had everything, but then the question became, what did we have after colonization? And it was a split decision, but it was 5-4, and it still went in our favor. And they said, well, we obviously still had the rights to hunt, fish, and gather because there wasn't anybody feeding us, there wasn't a grocery store, and things like that. Our treaties, in fact, are much different than the West Coast treaties and other treaties. And in our 1837 treaty, it says that we retain the right to hunt, fish, and gather on the wild rice on the lands, rivers, and waters that we are ceding. So that means we still have the use of all of that territory, in the sense that, Bruce was talking about and so forth about how big is your territory. Our territory is the same territory from the beginning, from 1825. There were just land cessions. Well, wild rice is in the treaty because wild rice is probably our most important spiritual connection. Wild rice is our creation stories talk about how wild rice, the food that grows on the water, we went in search of it across the Great Lakes and found it, and it was through prophecies and visions. And so our spirituality is connected to it. And we have a covenant with nature because nature provides food so that we can exist. And so we have an obligation to protect nature. But we've had the same problems everybody else has had with nature. The capitalism kind of gets a hold of the laws, and you can't protect nature, even if they call it the Environmental Protection Agency. They're really permitting, they're not protecting. And so, law is a funny thing. It's colonial, it's institutional. You don't know that you're boxed in a lot of times because of the way the rules work and the way the cases are developed and so forth. And as I started working with the rights of nature people, Tom and Mari in particular here at the Center for Democratic Environmental Rights, I started looking at their tools, and I could see a different way to use their tools because we were an Indian country. And they were trying to explain to people, and I'm sure there's people here right now in the same circumstance that don't exactly have power over their government, and they weren't exactly sure what their rights were because they were trying to protect nature. And as we discussed things, we really kind of had to explain that we didn't just have a right to nature or of nature to protect rights of nature, but we have a right to nature to hunt, fish, and gather. And we have a covenant with nature to keep it alive and always be there for everyone in perpetuity, as was being discussed. And so if we have an obligation in our culture to keep everything together for all of the people in the future, then that's an environmental protection. Wild rice is a very sensitive grass. It's an aquatic grass. And because it's specifically mentioned in our treaty in the United States, treaties are the law of the land in the Constitution. And so really we have a constitutionally protected treaty right, unlike almost any other place, I think, with Indians in Indian country. And so by using that wild rice, what we call monoman, as our law, that becomes the barometer in the environment. And protecting monoman already is tied to our culture and our spirituality. So it becomes a natural kind of a law, a customary kind of a law, but it's been codified. And because of what's been going on with Dakota Access, KXL, Line 3, I also made it so that it's a defense, so that we have a right to defend wild rice. It has a right to live, it has a right to flourish, it has a right to exist, but we have a right to defend wild rice. And wild rice is kind of an odd concept for most people. And really what we're defending is the water, because wild rice grows in the water, it grows in the air, and it grows in the earth. And if wild rice isn't being successful and it's being harmed, then we know there's a problem in the environment. Now, having said that, I'm going to deviate just a little bit. And I don't know if people are aware of this, but a friend of mine has a similar case that I have with rights of Monoman against the Department of Natural Resources here in Minnesota in federal court. And he has now sued the city of Seattle, Washington, and he's using rights of salmon. And so the salmon there are being cut off by the dams to make it upstream to where they normally would go and regroup and, you know, make more salmon and lay eggs and come back to the sea. And there's 3 hydroelectric dams on the Skagit River that provide all the power and light for the city of Seattle. And they're blocking all the salmon from going up. And so he's using rights of salmon in tribal court to get an injunction essentially against the city while they're trying to get re-permitted under the federal FERC, the Federal Energy Regulatory Commission, so that they can get the kinds of mechanisms to restore fish ladders or whatever mechanisms allow the fish to migrate upstream again, because that's their primary treaty right. That's their primary treaty food. There's already decisions about this in our courts. And so that's why I've modeled rights of Monoman after the fish. Now, what I would tell you is I think rights of fish are going to replace rights of Monoman. And I think that because Monoman or wild rice, when I say that, some people know what wild rice is, most people probably don't. And everybody knows what a fish is, even if it's a goldfish. And everybody knows what a live fish looks like. Everybody knows what a dead fish looks like. And everybody knows what 1,000 dead fish look like. And that makes them think there's something wrong with the water right away. And that's important because that's really what you want, is a barometer that can help you when you're saying the rights of something to exist. You can tell right away if it's existing. Wild rice is a plant. It grows, it disappears, it comes back, it migrates in like nature does in other kinds of places. And so it's not as easily to rely on. The interesting thing that I've found, because of the way the laws in the United States, and maybe somebody will find something in Canada and other places, but because we're Indians and we were separated out in the Constitution in the beginning, we're Indians not taxed. Congress is the only authority that can deal with Indians. Indians have treaties. Well, Indians aren't citizens. And so when they made the Bill of Rights, the first 10 amendments, the 11th amendment that they made a little bit later says that citizens can't sue their state, and the citizens can't sue governments of another state. Well, we're not citizens of the government because we're Indians. And so all of a sudden, the state of Minnesota has discovered in federal court that we have sovereign immunity and they don't. And so they lost in federal court already, where the judge asked DNR, show us the law that says I can tell them that they can't bring you into court under their jurisdiction. The DNR couldn't show anything because it's never been done before. It's a new concept. And so they appealed to the 8th Circuit Court of Appeals. And in the United States, they say that that's almost the highest court of the land because the Supreme Court only does about 200 decisions a year, and the other circuits do all the other decisions. And so we're waiting right now. We had oral arguments, but we're pretty sure that they're also going to say, you got to exhaust your administrative remedies in tribal court. And we're going to take these people into tribal court, just like they're doing in Washington state right now to the city of Seattle. And we're using our laws in a way that haven't been used. We're using them in a traditional, customary way, which is a very low-level kind of mechanism, but that's the kind of laws we're allowed to make for ourselves under the federal laws from our government. And so it says something like any law heretofore or hereafter that isn't inconsistent with state law, and it's a custom or an ordinance, well, then it should be used to decide things. Wild rice is the state grain. Wild rice is protected by the state of Minnesota. We're doing the same thing. It's very interesting. We have a tribal court. They have a tribal court. We're not inconsistent. We have water rights. They have water rights. And so I've set up a parallel system that changes the environmental battlefield and relevels it. Now, I suspect that when the Eighth Circuit comes out and says, Minnesota, you're going to have to go to federal court and exhaust your remedies, Minnesota's going to come and say, let's work this out. Now, that's good, but we need to make that work for all the tribes and all the Indians. And so with the Chippewa, like I said, we're 800 miles across. We're across the Great Lakes. We have 44 treaties. We have the same treaty rights. And so when we submitted our brief to the Eighth Circuit, there were 7 other Chippewa bands that also put in an amicus brief because they know these are their rights too. And they can see that I've created a different mechanism, luckily enough. You know, you got to try things, but that can hold the natural resource agencies and the permitting agencies like the Pollution Control Agency in check, because that's our jurisdiction. Environmental rights, the right to protect the environment and the right to live off the environment and the right to preserve it for our future generations, instead of the way the states have just, you know, continuously allowed degradation. You know, we have to stop them. And so we have to work on our water rights. And I think this is going to be the model going across the United States here shortly, because why wouldn't all the other tribes have the same rights for water? And we're using what we call the Montana exception, health, safety, and welfare of the people. This is food security. This is food sovereignty. This is clean water. This is the most basic part of survival on this planet. How could we not have a right? I don't know where I am on my time.
You still have time.
Okay, still have time. It's 5 o'clock somewhere here. All right. So we're having a good time by doing this, but it's also sad in some ways because you have to learn along the way. What we've also learned through science and other things is that when they came through to do the horizontal directional drilling through our environment, they didn't understand just how porous the gravel and the sand was from the glacial activity. And so we have a whole bunch of, we have several aquifers that have been broken and that we're continuing to run. One of them flowed for almost a year. They figured it was 3 million gallons a month that was being lost. This is during a drought year, and they're being permitted to do this. It was a very hard year for the people to go out and harvest wild rice. The climate change things that are happening everywhere. And we have to figure out a different tool to stop the permitting. And I think this is going to be it. It's a real simple kind of a concept, but in a sense, if you can make a project go through your laws for a couple of years and then go to federal court and you've set the record with the kinds of information you want in the record to be decided, it's a lot different than what the state does. Because the state just doesn't accept them. The state already has its own motivations. The state has a whole bunch of attorneys. They have a whole bunch of courts. They have a whole bunch of law enforcement. So the other thing I would just say for Indian country, because we're talking about indigenous things, I work with Winona Leduc a lot. And one of the things, because rights of Monoman is a defense, and because we have treaty rights, I was able to articulate well enough to some of the judges that we can't be considered trespassers because we have a right to be in public places and public waters, unlike citizens of the state of Minnesota who aren't in possession or treaty beneficiaries. And so I helped judges understand that you can't charge us with trespass. And if you can't charge us with trespass because we're really on our own property, then you can't, get us for nuisance or unlawful gathering, unlawful assembly, those kinds of things. And so all of these cases, all of these charges with tribal members, not just Chippewa, but even other tribes, have all been transferred to tribal court. And so people aren't ending up with criminal records. And as a result of that, and this is kind of an odd nuance, but the people that are left in state court aren't Indians, and they're mostly white people. And how mean do you want to be to those water protectors if the Indians are no longer being harshly dealt with? And so a lot of people are beginning stages of adjudications and better deals on settling out and things. And so as we learn how to use our power in a different way and use their laws against them, then we have a better chance. The problem is figuring out how to use their laws against them. But I have to believe that the mechanism exists. I've found one, I believe, And I'm hoping that the young people behind me will figure out how to use this tool to pry open the doors of justice and re-level a lot of the battlefields that we're on. But it has to be at the level that we have a right to across the territory, a right to travel, a right to water, a right to land. People have asked me about rights of a tree, for carbon sequestration. Well, we have a symbiotic relationship with trees too. We all do. We breathe what they exhale, they exhale what we breathe. I mean, how much more basic can you get? And so when you start thinking in those terms about your relations, it's a lot easier to protect them. All right.
Thanks, Frank, for your sharing on the rights of nature. I think I have already collected a number of different questions, and I will distribute to each one of the speakers later. And that's save our time. Just go to our today's last speaker, Bradley Cardozo, and today he is going to talk about climate justice, indigenous politics, and coal in Arctic. So I'll turn to you. Thank you.
Thank you, Professor. I'm just gonna share my screen. Okay, cool. Can we see my PowerPoint? Hopefully it's visible. Okay, thank you. Hi everyone. Sorry, let me just fix my screen. Okay, yeah, it's really an honor to be on this panel, and thank you. I've learned so much already, so thank you everybody, and thank you to the organizers too. The title of my paper is Climate Justice, Indigenous Politics, and Coaligarchy, the coal-powered threat to the Aita Magbukun people of the Philippines. I think my presentation is going to be a little different from other folks on the panel. I ended up actually joining, this is part of my dissertation research on the climate justice movement in the Philippines. And I began doing my research with a climate justice advocacy group in the Philippines. And then I ended up learning about the organizing that they began initiating with an indigenous group in the Philippines. So yeah. Okay. On November 20, 2018, a hearing was conducted in a barangay or a village in the municipality of Mariveles in the Philippine province of Bataan on whether or not the Philippine government's Environment Department should authorize the construction of yet another coal-fired power plant in Bataan province. There are already 6 functioning coal plants in Bataan, with 5 more coal plants in the pipeline. And this would be the 2nd coal plant in the municipality of Mariveles. Representatives of San Miguel Corporation made their case for the construction of the polluting coal plant in a province already saturated with toxic emissions from coal burning, and regulators from the Philippine government's Department of Environment and Natural Resources asserted that the proposed coal plant deserved to be granted an environmental compliance certificate and that it allegedly passed the standards of the Philippine government's Clean Air and Clean Water Acts. After these presentations from the corporate and state representatives, members of communities living next to coal plants in other parts of Bataan province waged a powerful opposition to the proposed coal plant. Members of Lamau Concerned Citizens, a group set up by the Tagalog and other lowlander people of Lamau Village, where a San Miguel Corporation-owned coal plant is already operating, lambasted the proposed coal plant in Biaan Village. They shared stories of their own experiences living next to a coal-fired power plant, which started operating in 2017. They spoke about having to breathe in terribly toxic air on a daily basis, informing the crowd that it hurts to breathe, masakit huminga in Tagalog. It's painful in the nose and in the chest, masakit sa ilong, masakit sa dibdib, and that ever since the coal plant started emitting massive amounts of toxic fumes, their community, especially young children and elderly people, have been experiencing asthma attacks, difficulty breathing, dizziness, and terrible rashes. A baby grandchild of a fisherman died while coughing, and elders have been suffering from debilitating lung diseases. Fisher folk from that community also reported that the fishing resources near the coal plant, where they had been fishing for decades, had drastically declined, and that the fish remaining are poisoned. They also testified that there had once been abundant sources of clean water available 24 hours, 7 days a week from the nearby stream, but now they have to obtain water rations and purchase expensive bottled mineral water because the coal plant had been devouring up the water supply. Meanwhile, people near the coal plant faced demolition and displacement. Large parts of the financial compensation that some families should have been given were swindled away. And they said that only about 10% of the current workforce in the coal plant are from the area, with the vast majority from other provinces. One woman, a fierce advocate against coal in her community, and an officer of this group, referred to the coal plant in her municipality of Limay as a demonio, or a demon. One man in the crowd, that's him, who had been quietly listening to both the coal industry's presentation and the testimonies of the coal-affected community members from the other municipality, went up to the microphone and asked the government and corporate representatives a series of questions about how the coal plant would impact the livelihoods of the people in the mountains. This man was a special counselor in the municipal government of Mariveles. Unlike the other council members on the council, this man represented the ancestral domain of the Aita Magbukun indigenous people. He is also a member of the tribal council representing the Aita Magbukun. The counselor asked, quote, "For us indigenous people," he used the term katutubo, the Tagalog word for indigenous people, "who live in the mountains with trees, animals, swidden crops, and rivers, what will be the effects on our livelihoods of this coal project?" The woman representing the government's environment department claimed that because the emissions from the plant would allegedly meet the standards in the Clean Air Act, the livelihoods of the indigenous peoples would not be adversely affected. Unconvinced, the indigenous counselors subsequently agreed to a meeting with representatives from the Coal-Free Bataan movement, which is a member organization of the national coalition in the Philippines called the Philippine Movement for Climate Justice, which had been relentlessly organizing against coal power in the province. These anti-coal and climate justice advocates had actually been trying for a long time to meet with members of the Aita Magbukun tribe to find ways to work together against the threat of coal power expansion in Bataan province. In this paper, I'm exploring how the rise of climate justice advocacy in the Philippines is producing new and innovative forms of political and cultural convergences between indigenous and non-indigenous or lowlander peoples of the Philippines in the struggles for both environmental justice and indigenous sovereignty. This is just a part of my larger dissertation project on the climate justice movement in the Philippines, which has been waging battles across the country to halt all coal power expansion, to promote 100% renewable energy generation instead, while imploring the industrialized nations of the global north to provide climate reparations to vulnerable global south nations like the Philippines in the form of finance and technological transfers that would facilitate the transition to the clean, sustainable economy that is necessary to avert a global climate apocalypse. Elsewhere in my dissertation, I argued that the primarily fisher folk community, which had provided the powerful testimonies in opposition to the coal plant at the hearing, I consider them to be both climate justice advocates and insurgent ecological citizens. But for this paper, I focus on the relationship between Filipino climate justice advocacy and indigenous sovereignty, and the political and cultural power that is emerging from the convergence between these social and activist forces. So for the remainder of the paper, I focus first on the expansion of coal power in the Philippines and the national opposition to this from the climate justice movement. And then I analyze the situation of the indigenous Aita people, also called the first peoples of the Philippines, and the vulnerability, marginalization, discrimination, and violent oppression that they have endured from what has been termed the post-colonial settler state of the Philippines, and I'll describe that too. And finally, I'll reflect on the emerging forms of cultural and political power that are being generated from the meeting between climate justice and indigenous sovereignty in the Philippines. And so ultimately, I aim to ask or answer the question, what does climate justice organizing and advocacy look like in a post-colonial settler state? Increasingly in countries worldwide, particularly in Western Europe and North America, coal-fired power plants are being increasingly decommissioned and shut down due to both the global prices of wind and solar power now being cheaper than fossil fuels, as well as the increasing recognition of the terrible environmental, climatic, and health impacts of fossil fuel burning. Despite this, rising Southeast Asian economies, including the Philippines, have been increasing their consumption and use of coal power, with critical financing coming from the World Bank, banks in the US, China, Japan, and South Korea, and financial institutions from within the Philippines. Currently, coal power accounts for about 40% of the Philippines' energy resources. About 30% come from renewable energy sources. But at the current rates, coal power could be up to over 70% of the Philippines' energy supply. As Filipino climate justice advocates have contended, this will have debilitating and ultimately apocalyptic impacts on the people of the Philippines, which is one of the most vulnerable countries on earth to the impacts of the global climate crisis. The Philippines has already been experiencing a greater frequency and intensity of monstrous super typhoons, along with more severe flooding and droughts. And it's facing, along with the damaging effects of this extreme weather that has accompanied the climate crisis, the archipelagic nation also faces a looming mass migration crisis as sea level rise threatens to inundate numerous islands and coastal regions across the country. Southeast Asian as a region alone could see over 100 million climate refugees in the coming decades. As environmental justice proponents have also noted, the health impacts from the burning of coal are deleterious for communities living in the vicinity of coal-fired power plants, coal mines, and coal storage facilities. Nowhere is this more apparent in the Philippines than in Bataan province, in the main northern Philippine island of Luzon, where once lushly forested areas and white sand beaches in the province are now despoiled with pollution and saturated with toxic air from 6 functioning coal plants, a diesel power plant, and a coal ash storage facility. So in response to this, social and environmental justice proponents have waged powerful people's movements to fight against coal power expansion, economic dislocation, and political violence in Bataan. At the forefront of this is the Coal-Free Bataan movement. Now it's called the Nuclear/Coal-Free Bataan movement, which is a member organization of the Philippine Movement for Climate Justice. From 2016 to 2018, I conducted ethnographic research with the Philippine Movement for Climate Justice, both in its national headquarters in Manila and in provincial branches around the country, including in this province of Bataan. So it was in Bataan where I first personally encountered the emerging alliance building activities between Filipino climate justice advocates and Indigenous peoples of the Philippines. So the Indigenous nation whose ancestral domain will be directly impacted by the construction of San Miguel Corporation's coal-fired power plant in Mariveles municipality is the Aita Magbukun. The Aita Magbukun have traditionally been a semi-nomadic hunter-gatherer and forager peoples. In their ancestral domain in Bataan today, they primarily engage in honey harvesting, foraging of freshwater shellfish and tubers, some swidden farming, small-scale charcoal production, and hunting of wild boars and other wildlife. Politically, they have a tribal council with a chieftain, council members, and other officers. They also have a special representative who serves on the municipal council of the local municipal government of Mariveles. And in terms of religion and spirituality, most Aita Magbukun are Catholic today, but Indigenous spiritual beliefs also permeate many of their worldviews and spiritual relationships with the natural environment and the ancestors. However, the ability for these Aita Magbukun to practice their ecological, economic, political, and spiritual practices, in other words, their ability to enact their Indigenous sovereignty, needs to be understood within the wider political context of indigeneity and threats to Indigenous sovereignty in the Philippines. The Aita Magbukun belong to a larger grouping of Indigenous people of the Philippines known as the Aita peoples. Aita has become an umbrella term for these Indigenous peoples, including Aita, Agta, Dumagat, Ati, and other groups. The Aita peoples of the Philippines have been referred to as the first peoples of the Philippines. They're really the original OG Indigenous peoples of the Philippines. In the post-colonial Philippine nation state, a complicated politics of indigeneity has emerged from the convergence between global discourses and activism of indigeneity since the 1990s, and the Philippines' own 400-year history of foreign invasions, occupations, and colonial rule, specifically by the Spanish, US, and Japanese empires. The Spanish colonial system of divide and rule was based on fundamental ethno-religious and ultimately racial distinctions between lowlander peoples of the islands who were more directly colonized and Catholicized and Hispanized by the Spaniards, and Highlander and other peoples who had resisted direct Spanish colonial rule for over 300 years, including the Bangsa Moro or Muslim sultanates, primarily in the southern island of Mindanao, and various animist nations throughout the islands. After a genocidal conquest by the United States beginning in 1899, the US colonial regime retained and built on the Spanish colonial ethno-linguistic divisions by defining and separately administering the Catholic ethnic groups in the lowlands on the one hand, and the Muslim and animist nations on the other. So the post-colonial Philippine nation state inherited these ethnic and racial classifications, with the so-called cultural majority of the Philippines, including the Catholic ethnic groups, such as the Tagalogs and the Ilocanos, and the cultural minorities became the Muslim and animist groups that had resisted direct Spanish rule. However, while the ancestors of most people from the Philippines, both indigenous and non-indigenous, first arrived around 5,000 years ago, the ancestors of these people, the Aita indigenous peoples, arrived around 60,000 years ago. So this was in the context of a great migration into Southeast Asia, Australia, and the Pacific Islands by the ancestors of the Aita peoples of the Philippines, Papuan people in New Guinea and Indonesia, Aboriginal Australians, and so forth. So yeah, they're the original indigenous peoples of the islands. But unfortunately, due to a Western colonial legacy marked by white supremacy, colorism, and racist ideologies that categorize some people as civilizationally and racially advanced and other people as backward and inferior, the indigenous people of the Philippines, and especially the Aita peoples, have faced drastic forms of ethnic and racial discrimination, economic oppression, dislocation, and land grabbing, and other forms of state-sponsored settler colonialism. I want to follow Filipino scholar Christopher John Chanco. In following him, I identify the Philippines as a post-colonial settler state. Post-colonial in the sense that the Philippines had received independence from the United States in 1946 after centuries of foreign colonial rule, but also settler colonial in the sense that the post-colonial Philippine state continued and even exacerbated several of the settler colonial policies initiated by the US colonial regime. In the southern island of Mindanao, for example, which had been 90% Muslim in the beginning of the 20th century, is now 11% Muslim today. And that's due to a state resettlement program initiated by the US colonial government that sponsored a massive migration of people from the Catholic ethnic groups in the north and middle of the Philippines, thus displacing the indigenous Muslim and Lumad peoples. In the northern island of Luzon, Aita and other indigenous peoples have experienced constant encroachments onto and displacement from their lands due to corporate and state development projects, tourism projects, mineral and extractive industries, fossil fuel industries, and so forth. And a group of Aita Magbukon people living in the same province of Bataan that I've been talking about in a nearby municipality of Morong had even faced displacement and eviction from their ancestral lands in 1980 due to the dictator Ferdinand Marcos's government's construction of the Philippines Refugee Processing Center, which had temporarily housed 400,000 Vietnamese, Laotian, Cambodian, and Hmong refugees who were fleeing from US Indochina wars in the 1970s and 80s. So they built a refugee processing center, but evicted the indigenous Aita people in order to build this center for refugees from the US invasion of Vietnam. So in the context of coal power expansion amidst a dire global climate crisis and this local health crisis, and in terms of post-colonial racism and settler colonialism against Philippine indigenous peoples, a new alliance was formed in December of 2018 between the mostly Tagalog and other non-Indigenous lowlander people who are part of the anti-coal, anti-nuclear, and climate justice movement in Bataan province, on the one hand, and members of the Aita Magpupun Indigenous Nation. A couple of representatives from the coal-free Bataan movement, along with myself, I came along, were invited by the tribal council of the Aita Magbukun tribe to visit their state-recognized ancestral domain in the mountains of of the village of Biaan in Maori Rights. The climate justice advocates, specifically Derek Kabe, I called her Ate Derek, Ate means older sister. She's awesome, by the way. She gave a PowerPoint presentation on the detrimental health, social, ecological, and climatic impacts of coal burning in Bataan. She narrated in more detail the ways that the fisherfolk community living adjacent to the coal plant in the other municipality in the province had been suffering not only from terrible health impacts of the toxic emissions from the coal plant, but they had also been suffering from intimidation, threats, and political violence. For example, in July of 2016, Gloria Capitan, a beloved fish vendor and grandmother who became a staunch activist against coal power, was shot to death by masked gunmen on a motorcycle in front of her own grandchildren. She was gaining more and more power for the anti-coal movement in her province. And this is how I really starkly learned about just how dangerous climate justice activism is in the Philippines and why the Philippines has been ranked either #1 or #2 in the world for most dangerous country on earth for environmentalists. It's either 1 or #2, depending on whether Brazil is #1. In response to the presentation, several members of the Aita Magbukun Nation voiced concern over the proposed coal plant, and the Indigenous councillor in the municipal council stated, that he realized this is not a good thing. He made a statement saying that this coal plant, it's really not a good thing. So this meeting served as the beginning of a relationship between the Aita Magbukun Nation and the nuclear and coal-free Bataan movement. I had planned to return to the Philippines during the summers of 2020 and 21, but I haven't been able to because of the lockdown and the pandemic. But I plan to return later this year, where I really, where I hope to get to just talk to people more and get more into this. But I just wanted to conclude with some thoughts and reflections on the potential and emerging cultural and political power that is being generated in these new 21st century forms of alliance building between leftist climate justice activists on the one hand, who are primarily non-Indigenous or lowlander people backgrounds, and Indigenous peoples of the Philippines on the other. The climate justice movement, and more broadly, the various social and economic justice and leftist movements in the country, have been, while they've been based on having a core set of principles, beliefs, and a worldview derived from leftist Philippine social movements, traditions of anti-colonialism, anti-imperialism, anti-fascism, and anti-capitalism, they haven't, at least in earlier decades in the 20th century, haven't always had the best or most aware practices or policies regarding environmentalism, gender and sexual justice, and Indigenous politics. But over the past several decades, and particularly in the 21st century, critical analysis and advocacy on women's rights, LGBTQ rights, Indigenous sovereignty have been gaining in power and sophistication in the Philippines. In the legal sphere, Indigenous power in the Philippines has increased, particularly since the passage of the landmark 1997 Indigenous Peoples' Rights Act in the Philippine government, which led to the creation of the Philippine government's National Commission on Indigenous Peoples, which is meant to advocate for Indigenous peoples in the context of in the legal sphere in the Philippines. To counter land grabbing and other forms of settler colonialism against the Philippines' Indigenous peoples, the Philippine government also began legally recognizing the ancestral domains of the Indigenous peoples, which allows for Indigenous self-governance within marked territories demarcated by the state. And so these Indigenous Aita Magbukun peoples were able to live, have their livelihoods and practice their practices because they've been able to have their ancestral domain protected, whereas so many other Aita peoples have faced displacement from different developers and state forces. Moreover, both Philippine climate justice and Philippine indigenous politics have forged linkages with global activism surrounding the climate crisis and indigeneity, respectively. So in light of all this, in this paper, and just more broadly, what I'm exploring in my dissertation project on the Philippine climate justice movement, I'm exploring how Philippine climate justice advocacy and futurity is and really has to be fundamentally based on political, economic, and cultural decolonization. And that Philippine decolonization has to be premised on the prioritization of indigenous sovereignty and worldviews. Yeah. Okay, thank you.
Thank you, Bradley. And I really want to thank our 4 speakers today for their sharing on different topics. And for myself, I think the thing Bradley has brought up on the idea of indigenous sovereignty just echo to Professor Toki's like community with the Mana Whenua, which is the emphasis on the indigenous authority over even our natural resources, land, and what you 4 speakers has already share to all of our participants. So like I said, we have collect our questions from Facebook and other live stream platform. So far I have already received some of the questions for different speakers. So on to the next section, we have around like 15 to 20 minutes for our speakers. You might want to take this time to share more, especially, of course, you can answer on the question first, and you can add more on other thoughts you want to share. So the first question is to Professor Toki. And the question is that you mentioned legislative protection for rahui. And does the government accept the community's views of the diminished resources? And is there a conflict? And how is it decided? So this is the question I received for Professor Toki. So you want to take a minute?
Oh, no, thank you for the question. Really good question, and something that I didn't include in my presentation, but intrinsic within the seeking a rahui is consultation, right? So not just talking to our own community and our kaumata and our elders and our queer to ensure that we have the right guidance and the right tikanga and the right approach to lay the rahui. But also there's a huge, government consultation, that formal process. So they, on the other hand, the government, they talk to recreational fishers, all the stakeholders within the area, all the interested parties. So they gather their views in terms of whether they consider laying a rahui is not just justified, but also valid. So the minister needs to be assured that there's reasoning to lay the rahui, so there is a problem indicated and that this is the right approach for it, but more importantly that everyone, he doesn't upset too many people basically, and everyone's sort of on board. So yeah, there's a big process involved. There's public notification in our papers, lots of discussion. So it's up to Mana Whenua to ensure that they've done their homework prior to not only laying the rahui, but ensuring that they have the support of the wider community to ensure that that rahui is successful. So we contacted our local community board or local council authority, I suppose is a nice analogy there. And they supported us. We contacted small non-Maori communities on our island, and they supported us because, the facts is that we are, our fishing stocks have been depleted. And that's something that's a fact. The fact is that people do come to our motu, to our island, and take, you know, because we're 50 nautical miles east of Auckland, and you know, by the time they get out there, they think they deserve to be able to take as much as they can. They fill their freezers up, they have charter boats, and it's basically unchecked, and they just go back to Auckland. We're not against people fishing, but what we are against is not doing it in a sustainable fashion. So there's a whole process in terms of ensuring that the rāhui is robust, and it does stand up. So not just a tikanga Māori or a te ao Māori approach through our community and through our local community, but of course the ministerial or the national approach or the national support to have the rāhui laid. However, in saying that, if the minister for whatever reason decided not to support the rāhui, we would still stand behind our tikanga and the laying of our rāhui. So they still had that soft law approach, that moral underpinning for the rāhui that would still remain. Thank you.
Thank you, Professor Toki. And I have the next question is for Bruce. So the question is that you mentioned that in order to maintain Aboriginal title, you must maintain a connection to the land. Does this mean that First Nations cannot develop the land? So
Thanks. That's a really good question. So the short answer to that is no. First Nations can develop the land, and they do. They can't develop the land in such the way that it would be to the extent that they would destroy their connection to the land. So what that means in a factual situation, we don't really know yet. It's a principle in the law, but we've not had a situation where that's come up yet. Maybe just a couple more points. I just wanted to pick up on a couple of the points that my fellow panelists were making. Frank, I don't know if you're aware of this, but you're probably an Aboriginal person under the Canadian Constitution. One of the interesting things we've had developed recently from an international perspective is there was a decision from the Supreme Court of Canada here last year, which basically said, you don't have to be a Canadian citizen to have protected Aboriginal rights in Canada. You can be an American citizen. But if, like in Frank's situation, when you have Indigenous nations whose territory before the imposition of the border cut them across, like Frank was talking about, even the American cousins south of the border, like Frank was saying, we call them the Salmon Anishinaabe, they can have constitutionally protected rights in Canada. And I know that's a really interesting situation. I helped argue that at the Supreme Court of Canada, how that would work, but it's important because it does start to peel back the onion of colonization there, and you're not limited to these barriers imposed by the colonizers. So Frank, you might come up someday. I've got a lot of Anishinaabe clients in Ontario. I do a lot of work there in Treaty 3 and elsewhere, have rights to harvest wild rice north of the border and fish. And just a couple of points, Bradley's presentation, I loved it. You know, one of the things I think for an international audience to keep in mind, that kind of environmental racism that you're talking about, that's unfortunately live and present here in Canada. Canadians like to post themselves around the world as this beacon of treating Indigenous people properly, and that's not the case. There's an ongoing colonial project here in Canada, and I've not to the extent that you're talking about, Bradley, but unfortunately, I've had a lot of my clients opposing liquefied natural gas lines, hydro dams, all these things, and being faced with the violence of the Canadian state, and particularly against Indigenous women. You know, we're just past the International Women's Day, you know, and the violence I've seen Indigenous women face here in Canada from the Canadian state, very, very serious and ongoing. So thanks for your time.
Thank you, Bruce. And I think you brought up very interesting cases that we are also noticed on the U.S. and Canadian borders. But in Taiwan, and actually in conducting the so-called traditional cultural practices in Taiwan, the Indigenous person, if you crossed the not actual international traditional territory, you will be sued, which means you can only practice the traditional culture like hunting, gathering, and fishing within your traditional territory. But it's not officially established yet, but we will confirm into a specific lawsuit. So I think it's a very interesting, and we need to follow up maybe in different states jurisdictions. Thank you, Bruce, for that. And also, maybe we can continue to the question for Frank. And Frank, you may also reply what Bruce just mentions. So the question for Frank is that what is the federal government's attitude towards the rights of nature project using tribal courts? Is it hostile? Does it support the state of Minnesota? I think that's the question for Frank. And Frank.
Well, you know, it's really kind of interesting because in a technical sense, the United States has this trust responsibility is what they refer to it as. And so I've tried to work with the Department of Justice with regard to protecting water protectors in the circumstances that I talked about with their trespass. We let them know that we were going to be suing the DNR with the rights of Monoman. And these concepts, because they're so out of the box, the Department of Justice couldn't even really comprehend, I think, what we were doing. And I think they're concerned about, in a sense, what we're doing because, and I'll tell you just a little bit different story about how we use our treaty rights, because you can already see from the conversation. So over in Idaho and Washington State, there was a couple of Indians, they were running cigarettes. They were father-son from running them from Coeur d'Alene, Idaho into Yakima, Washington. And they were selling them to non-Indian people without state taxation. And so the state was always trying to catch them, take their cigarettes away or make them pay tax or whatever. And so ultimately they ended up in court. And when they got to their treaty said that they have the rights to bring their goods to market on the public roadway. And so when they were transporting those cigarettes in a truck from Idaho to Washington, they were actually well within their treaty rights. And they were so well within their treaty rights that the Ninth Circuit Court of Appeals ruled in their favor, and they beat out the Homeland Security Act, the Cigarette Contraband Trafficking Act, and the Smuggling Act. And so when we started using that same kind of strategy against the Department of Justice when they were trying to prosecute some Indians here in Minnesota using the Lacey Act, which prevents you from catching wild game and transporting it and selling it to other people, that's against the law for other people, but we have treaty rights. And so we were able to show that the Department of Justice, who was attempting to prosecute us, didn't even have the right to prosecute us because our treaties were a defense. And so since then, we've used it a couple more times. One of the times we had a boat on Red Lake that capsized and we lost a couple of fishermen, and there was some civil litigation about that. And OSHA came in, the Office of Safety and Hazardous. They came in and they wanted to start fining and telling the Indians at Red Lake what they had to do. And we raised treaty rights again. And all of a sudden, OSHA had to pull back their fines and their their other, things that they were trying to control the circumstance, and they realized that our treaty rights beat out OSHA. We have a thing that's basically called laws of general applicability. Congress knows there's Indians. Congress knows who the Indians are. They know the Indians by name. And if they want a law to apply to Indians, they're going to say the word Indians in that law. Otherwise, that law doesn't just apply to us, especially if it conflicts with our treaty rights. And so what I'm doing is putting a lot more pronunciation on our treaty rights and using them in an environmental way that I think is going to threaten the United States as well, because we were unable to get the Corps of Engineers to actually do an EIS under the NEPA laws in the United States. And so without an actual EIS, the pipeline got through under the Trump administration. Now, we thought when Biden came in that there was still in the last year that they could still turn this project off, but they wouldn't even hardly talk to us. And what I've come to understand is because of the mining that's going on and the competition for exotic natural resources, nickel, copper, cadmium, things like that, they exist right here in Minnesota where I live. And so they're not as concerned about protecting the environment here because they say they can't go into the new green world and things like that without these precious metals. And now Elon Musk with Tesla has done a partnership with one of the mines that's about 45 minutes from here that they want to do the extraction from. Well, we are at the top of the 3 of the 4 watersheds for North America. That's why our fisheries are so good. We are at the top of these watersheds. And so what we're doing is we're doing the kind of mining and pipeline and oil things that are going to be the things that pollute the water at the top of the watershed out of 3 out of the 4 North American watersheds. And so, when I look at all of this, we're looking at the same kind of stuff that Bradley's talking about with climate change. We're worried about that. We're worried about what's going to happen to the fresh water. And we're worried about, what's going to happen to food. If the water comes up like he's talking about in the Philippines or any place else in Miami or on the East Coast of the United States, all of those people are going to be looking for higher ground. They're going to be looking for fresh water. They're going to look in where there's food that still lives on its own that they don't have to have on a farm because they aren't farmers. They're going to be poachers. So it's in my interest to prevent climate change, to keep all those people away from my beautiful place on the planet.
Thank you, Frank.
You bet.
And there's another question here I have is for Bradley. And I think because in the modern time, when the indigenous people have an issue with the government, there's always, we have to need to confirm the mandate on the indigenous groups. And so, and you also, in your presentation, you also mentioned a number of things about the representative. So the question is, how does an indigenous people get recognized? Is there any legal status in the Philippine legal system to recognize an indigenous people under the Indigenous Peoples Act or other legislations? So that's for Bradley. Thank you.
Thank you. Yeah, no, thank you, Professor. Yeah, I think definitely since the 1990s, I think that there's more and more laws have been developed. It's interesting because before it's quite new. I think that people are even using the term indigenous peoples. They would say cultural minorities. They would say other, there were other just kind of other terms. And then once the Philippine government ratified these United Nations conventions on the rights of indigenous people, and the Philippine government had its own Indigenous Peoples' Rights Act. That's when things really started, I think, heating up more in terms of indigenous rights. So yeah, that was really the landmark thing, the Indigenous Peoples' Rights Act. The Department of the DENR, Department of Environment and Natural Resources, they were the ones that began issuing what were called the ancestral domain titles. So this was in response to all of the land grabbing and just like other ways that indigenous peoples were being displaced. And so these that like and that this has been pretty key, like just for Indigenous people who have been like the Aita people who have been like unfortunately just like moved around, like just displaced constantly, like constantly forced to move for like development projects or anything really. Now that some of them are getting their these ancestral domain titles recognized, it gives them this sort of legal basis to just be like, okay, stop. The developers, everybody, like just like leave us alone. And so they're able, so like these Aita Magbukun people in this ancestral domain, they're able to continue like harvesting and continue their practices for like gathering honey and hunting and stuff like that in their in this mountainous forest. And so and there are other instruments too. I think that the after the Indigenous Rights Peoples Act was established, the Philippine government established the National Commission on Indigenous Peoples. And so this is a government agency that is meant to advocate for Indigenous peoples. It does some good work, but not, there have also been issues, you know, bureaucratic issues, corruption issues. So it's not a perfect commission by any means, but it's good that it exists. And then I think what's unique about this municipality that I was talking about, this local government unit of Mariveles, the local government decided to appoint a special representative from the Aita Magbukun to represent the people from their ancestral domain. And that was kind of just like a local government initiative. So yeah, I think that throughout the Philippines, like there's been stuff being done at the local level and the national level, and I think it's the social movement organizing that just from what I've seen, like you can't ignore that, you can't you have to pay attention to this now. So yeah, I think yeah.
Thank you, Bradley. And we are almost finished our today's sessions. And before I give each one of our speakers the time for closing our final remarks, and there's one more question I might suggest our speakers, you may also give your comments on that. The question is, in what way, if at all, do you think that environmentalist approach different from Indigenous approach on our today's topic? And so I think maybe we can just go by our order from Professor Toki. Thank you.
Thank you. In my using a romantic lens, I would like to think they are the same because they want to achieve the same outcome. So yeah, my short answer is that I'd like to believe that an environmentalist approach is the same as an Indigenous approach. However, if we think about what underpins each approach, an Indigenous approach is holistic and it's like three-dimensional. And I'm not quite sure whether an environmentalist approach is quite the same. Even though I'd like to think that the outcome or the result, we want to achieve the same thing, I just don't believe the starting points will be the same. There you go.
Thank you. So Bruce?
Thanks. Yeah, great question. I think based on my experience working with Indigenous people in Canada, and before I became a lawyer, I did a PhD in environmental history, and I see them as pretty different, at least here in Canada. They have overlap, but the main concern is how you'll get non-Indigenous people that will have an idea of what it means to protect the environment, and Indigenous people being part of the natural world, and often coming up to having their own agenda and being critical of Indigenous people when it doesn't line up with Indigenous people's agendas. My clients have always used their lands and waters in different ways. They don't see it as some kind of perfect nature that must be preserved like a park. They have a responsibility, a stewardship responsibility to the land, but it doesn't mean that they also don't derive resources and sustenance from the land. So I just see that conflict a lot here in Canada, and it's unfortunate unfortunate, but it's an educational issue for non-Indigenous environmentalists. Thanks a lot.
Thank you, Bruce. And let's get to Frank.
Well, that's an interesting question. It makes me think about these different kind of water protector activities, maybe like with Standing Rock and KXL and Line 3. I was talking to one of my elder friends and I was trying to understand what happened at Standing Rock, and he referred to it as a spiritual awakening. And we don't have those too much anymore. My spiritual awakenings were back in the 70s. And so I've been awake the whole time. I just forget sometimes that other people haven't been awakened or haven't been called or whatever. And so, I see us being called because of our covenant with nature, that we have an obligation to come and stand up. We have a duty in that sense. And environmentalists, I don't always know what that encompasses, because sometimes we have jokes here about like the DNR, half of them are planting trees and the other half are cutting trees, and they're both working for the Natural Resources Department. So which part of being an environmentalist are they doing at what time and what place? And it makes it hard for us sometimes to think about that. And when they first worked on our lands and bought our lands, if you want to say that, they wanted the trees. Well, we knew trees would come back. I live in the Chippewa National Forest. We don't need the U.S. Department of Forestry to watch the trees grow. We've been here for a long time. We can watch the trees grow. We know the trees are going to grow fine on their own, and we'll sell the trees later. But instead, we have an agency with a bunch of people who are getting paid a federal bureaucratic wage to drive around in trucks around the trees and paint them once in a while and say you can cut this one and a few other things. And it's just ludicrous in some ways that it would even exist like that. And they're the ones who are the authority in that regard. So environmentalism sometimes, gets in our way. And I think that's what kind of like what Bruce and the Dr. Talkia there was talking about. Bradley, obviously if you're a climate change, it's already in your way. So yeah, it's environmentalists mean well, but I think they don't always know what they mean. And so I would like to think we all want the same thing, but I think we have it intrinsically. And sometimes I think environmentalists think that there's only so much you can get at one time. And we don't think there's a limit. We don't see where there's a limit. We don't say, well, okay, we're just going to save the trees this time and we're going to let the birds go because we can't do it all. That wouldn't even make sense to us or something. So we don't work in those kinds of increments. We think in a holistic way. We think of everything. And so, there's places that look like a forest around here, but we call them plantations because they're a monoculture. There's thousands of the same kind of spruce Norway tree. And there's animals that live in there. There's birds that fly over it, and there's critters that, have little homes, but it's not a forest. It's not an ecosystem. It's just a bunch of trees waiting to get big enough to get cut down and cut into boards. So is that environmentalism or is it growing trees? So it's hard for me sometimes. I don't know. It's an interesting question. I might not even have a good answer. All right, good night.
Thank you, Frank. And let's hear from Bradley.
I feel like everybody said, I feel like that's everybody answered it. But for me, this question is like really at the heart of like what I'm trying to was trying to get at. I think what people were saying about the holistic thing, I feel like that's it. What I've noticed from the climate justice activists, they're coming, a lot of them are coming from this, a lot of them were veterans of this anti-Marcos dictatorship movement. Many of them were student activists. They were motivated by labor rights, a lot of issues, and their framing is often very secular, very scientific framing, and about like the climate, what does does the climate science say about how we need to live, and which is all important. But there's also what I've seen is just more and more just like at least respect for, or at least mentioning the need to respect Indigenous voices. But when I went to when I hear it from the Indigenous peoples in the Philippines, it's what Frank and what the other panelists, Bruce and Professor Toki, have said about like this holistic worldview. Like to be honest, it's very inspiring. It's very beautiful, like hearing about like the need for like respecting the earth and like really like living within our means, because we have to take care of the earth, because it's literally like what they like they talk about it like that one Indigenous counselor, he was talking about what's going to happen to the water, to the animals, to the to the plants. It's not just like what are the greenhouse gas emissions and the like sort of what quantity is allowed and stuff. So I guess for me, it's that holism thing and that I find really inspiring. And even like in the Philippines, here in Los Angeles, I've done a little bit of work with Tongva people and Hachimin people for they're trying to protect these wetlands that are being drilled for oil here in these wetlands in Los Angeles. And same thing, it's just very like the way they talk about the wetlands, it's just in a much more like spiritual sense, or it's a much more like connected sense. So yeah, that's why everybody needs to learn from Indigenous people, Indigenous perspectives. Like that's what I found from like, it's not complete without it. Yeah.
Thank you. And I think this is truly a very productive 2 hours, and I personally learned a lot from each one of 4 distinguished speakers. So I think we are just in time to finish today's panel. So I will turn back to Madeline to finish today's discussion. Thank you all. It's my pleasure.
Thank you, everyone. Thank you especially to our panelists and our moderator, Professor Awi, for sharing your knowledge on these topics with us. And also big thank you to all of our attendees here on Zoom and also on Facebook at the Engaged Scholarship in the Asia Pacific page for your participation, your questions, and your support of this webinar series. We do invite you now to fill out a survey. Earl is dropping the links in the chat box. This survey helps us improve our webinars, and you can also receive a certificate of participation. Feel free to contact us if you have any questions about either of those. We do have one final session left in the symposium. Next week is session 4, Economic Commercialization of Traditional Resources and Land. That will be same time, same place. So that's next Wednesday, March 16th at 6 p.m. if you're in Los Angeles, or Thursday, March 17th at 1 p.m. if you're in Sydney, or 10 a.m. if you're in Taipei. The Zoom link or the registration for the Zoom link is also available in the chat box. You can also look us up at dal.ucla.edu/engaged research, or you can search, do a quick Google search for the UCLA Center for Southeast Asian Studies website. And again, thank you everyone. Have a good night or a good rest of your day, and thanks for participating.
Thank you.
Thank you all.
Thank you.
Thank you very much.
Bye-bye.
Bye-bye.
Bye.